Good morning. Today I have gone through a fantastic judgment. It's information for me that in Mizoram there is some customary law of inheritance. Uh, the law pursues postgraduate students and particularly concentrating to obtain doctorate in law must go through this judgment and think the judgment with section 6, 8 and 15, 16, 17 of Hindu Succession Act, not even Indian Succession Act, Christian Succession Act, Muslim Succession Act. This seems to be very fantastic, timely required succession law. See, this is what happening nowadays. Earlier, because of the thick blood family living and residing under one roof by one woman, the relationship was so thick. Nowadays, since the distance between the relations are wide enough, spreading all over the globe, the affinity, affection, the duty-bound customary rights were also being now ignored. Protection of Senior Citizens and Parents Act is also enacted only for that purpose. Therefore, the Union government, if really interested to enact a common civil code, must keep this judgment in mind. It's a case where the Supreme Court held that in AR 2022, Supreme Court 2824, Mizo customary law of inheritance, right of inheritance under Mizo customary law depends upon consideration of equity and responsibility of legal heirs to look after elders in family. See, though the customary law of Mizo prohibits the daughters given in marriage are not entitled for inheritance, but however the Supreme Court has held this way. Under Mizo customary law, inheritance depends upon the question as to whether a person supports the deceased in his old age or not. If a natural heir does not support his parents, he would not be entitled to inheritance. Even if there is a natural heir, a person who supports the person until his death could inherit the properties of that person. In the instance case, son was looking after his mother. However, after his death, a daughter came to her original home to look after her aged mother. The provisions of Mizo customary law relating to divorced Haringir in the matter of inheritance would apply to her, and right to inheritance of her father's property subsists by virtue of her divorce. Since daughter discharged her responsibility by looking after her mother till her death and was occupying the main bed and reassuming her father's clan title, now her right to inherit her father's properties could not be defeated. Other female who is granddaughter from the male lineage descendant of deceased was unmarried and purely Hahu. It found that her right to inheritance in the instant dispute was safeguarded by the customary law in the absence of descendant having a better right for the purpose. Taking into consideration of principle of Mizo customary law of inheritance and the spirit of equity, which is paramount to Mizo, it was appropriate that property be divided between daughter and granddaughter. This is what judgment. Go through the judgment, not more than that I will help you. So, this is what somewhat feeding material for the postgraduate law students and those who want to achieve more in the legal field. Kindly go through the judgment. And unfortunately, today I had a message, Mr. Rajasekaran, Justice Sudhandaram colleague. Uh, I know him for more than 40 years, right from my beginning of practice. As I know Mr. Sudhandaram also, we start practice jointly from beginning. He is no more, very smiling face. I hope you understand my. I pray Almighty to rest his soul in peace. Best wishes.